General principles of insurance. Risk and uncertainty are part of life. A person may die at an early age. He may suffer from accident, destruction of goods and property from fire, sea perils and many other causes. It is to provide against risk and uncertainty of the aforesaid nature that insurance came into being. Insurance does not avoid or eliminate the loss arising from uncertain events. It only spreads the loss over a larger number of people who insure themselves against that risk. Thus, it is a cooperative device to spread the loss caused by an uncertain event which is covered by insurance over a large number of persons who are also exposed to the same risk and insure themselves against the risk. The risks which can be insured have increased in number and extent. Insurance business can mainly be divided into two categories, namely, life insurance business and general insurance business. General insurance business means fire, marine or miscellaneous insurance business, whether carried on singly or in combination with one or more of them, s. 6b of the Insurance Act, 1938. The law of insurance is contained in the following four acts. 1. The Insurance Act, 1938-2. The Life Insurance Corporation Act, 1956-3. The Marine Insurance Act, 1963. 4. The General Insurance Business Nationalization Act, 1972. The provisions of the Insurance Act, 1938 are applicable to both life and general insurance business insofar as these are not inconsistent with those contained in the special acts governing them. All types of insurance business have been nationalized in India. Life insurance business in 1956 and general insurance business in 1972. We in this chapter general principles of life, fire, and marine insurance contracts have been discussed. In 10.4 General Principles of Insurance. Definition of life insurance, 5 insurance, marine insurance and contract of insurance. The Insurance Act, 1938 gives the definitions of fire insurance business, s. 6a, life insurance business, s. 11, marine insurance business, s. 13 UL and miscellaneous insurance business, s. 13b, but does not give the definition of contract of insurance or the definition of any other special type of contract of insurance. Only s. 3 of the Marine Insurance Act, 1963 prescribe a definition of contract of marine insurance. Contract of life insurance. A contract of life insurance is a contract in which one party agrees to pay a specified sum upon the happening of a certain event, contingent upon the duration of human life, in consideration of the immediate payment of a smaller sum or certain equivalent periodical payments by another. The consideration is called the premium. It is payable either in one lump sum, e.g., single premium, or by successive periodical payments depending upon the terms of the policy and usually by way of periodical payments. In case of periodical payments, payment on or before the due date is generally the condition precedent to the continuance of the policy. A contract of life insurance or assurance is not a contract of indemnity. The person who promises to pay a specified sum is called the insurer or assurer, and the other party is called the insured or assured. Contract of fire insurance. A contract of fire insurance is a contract whereby one party undertakes to indemnify another against loss by, or incidental to, fire, happening within an agreed period, in return for payment in lump sum or by installments. It is a contract of indemnity. Contract of Marine Insurance. Section 3 of the Marine Insurance Act, 1963 says that, contract of marine insurance is an agreement whereby the insurer undertakes to indemnify the assured in the manner and to the extent thereby agreed, against marine losses, that is to say, the losses incidental to marine adventure. It is thus a contract of indemnity against loss, incidental to marine adventure, accruing to ship, cargo, freight, or other subject matter of a policy, during during an agreed voyage or voyages or during a specified length of time. It need not be limited to the actual loss sustained, as in fire insurance, not be limited to the actual loss sustained, as in fire insurance, but is generally based on value agreed to in advance, which may be greater or less than the risk involved. The consideration for the policy is called premium. The person who undertakes the risk is called the insurer or underwriter. Contract of insurance. A contract of insurance is a contract whereby one party, in consideration of sum of money called premium, undertakes to van certain law of insurance 10.5. Specified sum of money on death or on happening of any contingency dependent on human life or to indemnify the other party against loss by or incidental to fire or against marine losses or to make good the losses of another against any other specified risk. The party undertaking the risk is called the insurer, assurer or underwriter, and the party whose loss is to be made good is called the insured or assured. The document which contains the terms and conditions of the contract of insurance is called a policy, and the insured is, therefore, also called a policyholder. The consideration which the insured has to pay to the insurer to undertake the risk is called the premium. The amount for which the policy is taken is called the insured amount, or policy amount. The thing or goods or property which is insured is called the subject matter of insurance. The four essentials of a contract of insurance are: 1. Definition of the risk, 2. Duration of the risk, 3. Premium, and 4. Amount of insurance. A contract of insurance is a contingent contract as defined in S. 31 of the Indian Contract, 1872. It is not a wager under S. 30 of the Indian Contract Act, 1872. The general principles of the law of contract apply to a contract of insurance. General principles of contract of insurance. 1. Insurable interest. It is only the presence of insurable interest that distinguishes a contract of insurance from a wagering contract. All the statutes dealing with law of insurance say that contract will become a wagering contract and hence void if it is effected without an insurable interest. Then what is insurable interest? None of the above mentioned statutes attempts a comprehensive definition of insurable interest. W. H. Rodder says in his book, Fire and Property Insurance, insurance interest may be defined as an interest of such a nature that occurrence of the event insured against would cause financial loss to the insured. R. M. Ray in this book, Life Insurance in India, defines insurable interest as, when the assured is so situated that the happening of the event on which the insurance money is to be payable would as an approximate result involve in the loss or diminution of any right recognized by law or in any legal liability, there is insurable interest to the extent of the possible loss or liability. In Litchner vs. Croftierd, 1806, 2, Boss and PNR 269, H.L., Lawrence, J. Defined insurable interest thus: a man is interested in a thing to whom advantage may arise or prejudice happen from the circumstances which may attend it. Interest does not necessarily imply a right to the whole. 10.6 General Principles of Insurance. Of the insurance, which relation or concern, by the happening of the perils insured against may be so affected as to produce a damage, deterriment or prejudice, to the person insuring, and where a man is so circumstanced with respect to matters exposed to certain risks or dangers, he may be said to be interested in the safety of the thing with respect to it as to have benefit from its existence, prejudice from its destruction. Ownership or possession or the right to possession of the property insured is not a necessary requirement of an insurable interest. A legal right of use the goods, the benefit of which would be lost by their damage or destruction, might be sufficient to constitute an insurable interest therein. A person might also have an insurable interest in property if loss of or damage to that property would deprive him of that opportunity of carrying out work in relation to that property and being paid for such work. A person exposed to liability in respect of custody or care of property can, as an alternative to taking out liability insurance to protect his exposure, insure the property itself. It may be a right to the whole or part of a thing. The following points explain the nature of insurable interest. Tire interest should not be a mere sentimental right or interest. For example, a mere love and affection cannot constitute insurable interest. However, in India, in case of life insurance, sentimental interest or an interest based on close family relationship may constitute a sufficient insurable interest. In India, only an insurance contract which is in the nature of a wager is void, and it would not be reasonable to hold that an Indian father taking a policy on the life of the child is entering into a wagering agreement. It should be a right in property or a right arising out of a contract in relation to the property. The interest must be pecuniary. Mere inconvenience or mental distress cannot be regarded as insurable interest. The interest must be lawful, enforceable. The mere hope of acquiring an interest is not enough. Insurable interest and life insurance. 2. The time when the insurance interest must be present varies with the nature of insurance contracts. In Dalby v. India and London Life Assurance Company, 1854, 15 CP 5, it was held that the life insurance is not a contract of indemnity, and that it is enough that insurable interest should exist at the time of the contract, though not at the time of loss. This decision of the English court can be taken to be a contract without insurable interest is a wager. Comment, ul. B. D. Uj r greater than 7 W co. A. R. 1 Law of Insurance 10.7. 1 The law in India. This decision has been adopted by American courts also. Thus, in the case of life insurance, insurable interest must be present at the time of formation of the contract of insurance, and it is not necessary afterwards, not even at the time of occurrence of the risk or when the claim is made, as it is not, strictly speaking, a contract of indemnity. For example, when the creditor insured the life of the debtor, the policy continues even after the payment of debt. Similarly, when a husband insures the life of the wife or vice versa, the policy subsists, notwithstanding the dissolution of marriage, as the subject matter of the policy is life of other spouse and not the marriage. In Hersey vs. Pearl Life Assurance Company, 1904, 1 kilobyte 558. And Hughes v. Liverpool Victorial Legal Friendly Society, 1918, 2, K. B. 482. It was held that where a life policy is taken out by a person who has no insurable interest in the life assured, and so the policy is illegal, an action will lie for recovery of premiums paid if the person taking out the policy was induced to do by fraudulent misrepresentation on the part of the insurance company's agent, but not otherwise. A person has insurable interest in his own life, in the life of a person upon whom he depends wholly or in part for support, and in the life of any person who owes certain money to him. In India, certain dependent relatives have a legal right of maintenance. For example, a Hindu wife is entitled to be maintained by her husband during his lifetime and after his death by her father-in-law as per S. 18 and S. 19 of Hindu Adoption and Maintenance Act, 1956. A Hindu is bound to maintain his or her legitimate or illegitimate children and his or her aged and infirm parents according to S. 20 of the same Act. The heirs of a deceased Hindu are bound to maintain certain dependents of the deceased mentioned in S. 21 of this Act, out of the estate inherited by them from the deceased. Thus, apart from relationship, these persons have a pecuniary interest as well and may be deemed to have insurable interest in the life of the person who is liable for maintenance. According to M. N. Srinivasan, Principles of Insurance Law, 8th edition, 2002, reprint 2008, page 719. The insurance money that can be recovered need not be exact amount of maintenance or debt or other amount recoverable, because life insurance is not a contract of indemnity. It is enough that the amount bears a reasonable relationship to the value of the interest and is not speculative. In life policies, the following persons inter alia have been recognized as having insurable interest. 10.8 General Principles of Insurance. I. A person in his own life. Every person is presumed to have insurable interest in his own life without any limitation. If he dies, his nominee or dependents are entitled to receive the amount. E. A person in the life of his, her spouse. It is well settled that a husband has an insurable interest in the life of his wife and wife has insurable interest in the life of her husband. S. Habua in his book, Life Insurance, observes that, life insurance is a husband's privilege, a wife's right and a child's claim. The rule that a wife has an insurable interest in the life of her husband was recognized earlier on the logic that she depends on him. In Reed v. Royal Exchange Assurance Company. 1795, Peak, ad. Case 7. It was laid down that the husband and wife are presumed to have an insurable interest in the life of the other. It forms an exception to the general rule that interest necessary to support the insurance of another person's life must be capable of expression in terms of money or pecuniary interest. It should be noted that presumption arises only during the period of coverture, that is when they are husband and wife, and the policies taken during that period will be valid and will continue to be operative even after the dissolution of marriage. For example, A takes out a policy on life of his wife, B, and subsequently even if they are divorced the policy already taken will remain valid. On the other hand, if T takes out a policy on life of K, whom he proposes to marry, or who has been divorced by him, the policy is not valid due to lack of insurable interest at the time of commencement of the risk, that is, at the time when the policy is taken. A person does not have insurable interest in the life of his girlfriend, a would-be wife, E, parent and child. A child is presumed to have support. A son does not have insurable interest in the life of his father dependent on him for support or an independent father having strained relations with him. It has been laid down in relevant statutes in England that a parent has no insurable interest in the life of the child as mere love and affection is not sufficient to constitute insurable interest. If the person has any pecuniary interest in the life of the child, whether natural or adopted, he can take out an insurance policy on the life of such child. In America, apart from the relationship of husband and wife, a few courts have held that the relationship of parent law of insurance 10.9 and child, grandparent and grandchild, brother and sister is sufficient to revise the presumption of insurable interest. There is no express statutory provision in India on insurable interest. It is submitted that we may draw on the decisions of the foreign courts including those of England and America. In India, it is submitted apart from husband and wife in each other's life, child in the life of his, her parent, and person legally entitled to claim maintenance can take out an insurance policy on such other person's life without proof of insurable interest. IV. Other relations. In case of other relations, the relationship by itself does not create insurable interest. When one person effects an insurance on the life of his, her relative, there must be actual dependence on the person whose life is assured. Thus, in the case of other relations, insurable interest has to be proved. V. Creditor in the life of his debtor and surety in the life of the principal debtor. A creditor has an insurable interest in the life of the debtor to the extent of amount of the debt as the chance of getting the payment depends upon the continuance of the life of the debtor. Similarly, the creditor has insurable interest in the life of the surety, and surety in the life of the principal debtor. A policy taken on the life of the debtor continues to be operative even after the payment of the debt or debt becoming time barred. Again, a surety has insurable interest in the life of co-surety and a mortgagee in the life of the mortgagor. It should be noted that a debtor does not have insurable interest in the life of his creditor. In Powell v. Dewey, 1898-123 Log NC, it was held that a partner has insurable interest in the life of another partner only when the other partner is indebted to him or to the partnership and to the extent of such indebtedness. V. Servant in the life of his master. An employee has insurable interest in the life of his employer for his salary for the term of service contracted for. According to M. N. Srinivasan, Principles of Insurance Law, 8th edition, 2002, reprint 2008, page 233, in life insurance, close relationships such as husband and wife which cannot be strictly described as pecuniary, parent and child, employer and debtor, partners in business, may give an insurable interest in the life of each other. Insurable interest and fire insurance. A person is presumed to have insurable interest in the property if he has a pecuniary interest in the 10.10 General Principles of Insurance. Continued existence of property. In case of contract of fire insurance, an insured must have insurable interest both at the commencement of the policy and at the time the risk occurs, because this is treated as a personal contract and also a contract of indemnity. For example, if a house is insured against risk of fire, the person taking out a fire policy must have insurable interest in the house as it is a personal contract. If the owner of the house takes out a fire policy and later on sells the house, he loses the insurable interest and he cannot claim under the policy if the fire takes place and the house is damaged, as he has no insurable interest, because a contract of fire insurance is a contract of indemnity. Owner of property has insurable interest in property. A bailee has lien over the goods and is entitled to insure the goods for full value, as he will be liable for loss or damage to the goods to the owner. Vijay Kumar V. New Zealand. Insurance Company. 1954 Bohm. 347. An agent who is in possession of goods has an insurable interest in the goods for full value of goods. An agent without possession of the goods has no insurable interest. A mortgagor, as the owner of the property, has an insurable interest and he can insure for the full value of the property. According to S. 72 of the Transfer of Property A. CT, a mortgagee is entitled to insure the property but only to the extent provided in the mortgage deed, or if no amount is fixed, to the extent of 2/3 of the VA, UE of the property. It is further provided that mortgagee cannot get the property insured if there is already an insurance by the mortgagor. A lien or charge holder has insurable interest to the extent of the value of the lien or charge. The following also have insurable interest in the property: I. Warehouseman as regards customers' goods. E. Trustee or executor. E. A common carrier. IV. A finder of goods. V. Lessor and lessee. V. A lien holder. And V. Insurer himself. Insurable interest and marine insurance. According to S. 7(1) and S. 7(2) of the Marine Insurance Act, 1963, a person has an insurable interest if he is interested in the marine adventure. In particular, a person is interested in the marine adventure if he stands in any legal or equitable relation to the adventure or to any insurable property, and in consequence he may benefit by its safety or due arrival of the property, or he may be prejudiced by the loss or damage to the property or by detention, or may incur liability with reference to the property. In case of contract of marine insurance, insurable interest must be present at the time of loss and need not exist at the time of entering into the contract of marine insurance. The following person inter alia have insurable interest: I. Shipowner for full value. E. Cargo owner. E. The master or any member of the crew of a ship in respect of wages. IV. The law of insurance 10.1. V. The insurer of the ship or cargo. V. A seller of goods who has not yet received the price, or a buyer. 1. Person advancing money on the security of the ship, or any goods arriving by the ship. V. The insurer of the ship or cargo. V. A seller of goods who has not yet received the price, or a buyer who has not yet got possession of the goods. But the buyer of a vessel to whom property in the vessel has not passed has no insurable interest. A partial interest of any nature is insurable. The lender of money on bottomary has an insurable interest in respect of the loan. In case of advance freight, the person advancing the freight has an insurable interest in so far as such freight is not repayable in case of loss. Insurance premium can also be insured against loss by marine perils. The mortgagee of a ship or cargo also has insurable interest in the supercargo in respect of the sum due under the mortgage, and the mortgagor too has insurable interest to the full value thereof in spite of the mortgage. The mortgage, consignee or other person having insurable interest may insure on behalf of and for the benefit of other persons interested in the property as well as for his own benefit. Bottomary is a contract by which a ship owner borrows money for equipment, repairs, etc. Pledging. 2. Indemnity, a contract of insurance except life, personal accident and sickness insurance as a contract of indemnity. In Castelling vs. Preston, 1883, 11 QBD. 380, BREETT, LJ, said, "The very foundation, in my opinion, of every rule which has been applied in insurance law is this, namely, that the contract of insurance contained in a marine or fire policy is a contract of indemnity, and of indemnity only, and that this contract means that the assured, in case of loss against which the policy has been made, shall be fully indemnified, but shall never be more than fully indemnified." In Castellan's case, Preston entered into a contract to sell his hoseway which he had insured against fire. Before the completion of the sale, the house was partly damaged by fire. The insurer indemnified the insured. The buyer also paid the agreed price and completed the sale, and thus there was gain to the seller by the insurance. But the insurer came to know of this and sued the insured. It is argued on behalf of the insurer that there was no loss due to the fire, as the insurer received the agreed price from the buyer, and therefore there was nothing for which the insured had to be indemnified by the insurer. The court upheld the contention of the insurer and ordered Preston to refund the amount received from the insurer. Thus, indemnity is the fundamental principle in contracts of fire, marine, burglary and other property insurance. It means that the insured will be 10.12 General Principles of Insurance. Paid the actual amount of loss not exceeding the amount of the policy as the object of a contract of insurance is to put the insured in the same financial position, as nearly as possible, after the loss as if the loss had not taken place and the insured is not entitled to make a profit of his loss. In the absence of the principle of indemnity, the insured might be tempted to bring about the event insured against in order to get the money, and there may be tendency to insure the goods or property for more than their value, which will be against public interest. A contract of indemnity is a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person, as contemplated in S. 124 of the Indian Contract Act, 1872. But indemnity, as applicable to marine insurance, must not be an indemnity, as contemplated by the Indian Contract Act, as the loss in such a contract is covered by the contract itself, and such loss is not caused to the assured by the conduct of the insurer nor by the conduct of any other person. State of Orissa vs. United India Insurance Company Limited. Air 1997, South Carolina 2671. In actual practice, the terms of the policy may prevent indemnity of actual loss. For example, the actual loss may be greater than the sum insured in policy may be subject to average clause. In marine policies, the contract is to indemnify, in manner and to the extent agreed. S. 3 Marine Insurance Act, 1963. Thus, in practice there is only a commercial indemnity rather than a strict common law indemnity. Life insurance, personal accident and sickness insurance form an exception to the indemnity principle as no money payment can indemnify for loss of life or bodily injury. Moreover, valued policies where the value of the subject matter is agreed beforehand, are strictly speaking also an exception. 3. Subrogation. The doctrine of subrogation is a corollary to the principle of indemnity and applies to fire and marine insurance. According to it, the insurer steps into the shoes of the insured when he has paid the actual loss suffered by the insured, as the insured is not allowed to make a profit out of his loss. In other words, the insurer is entitled to the advantage of every right of the insured against a third party. This applies to all policies of insurance which are contracts of indemnity. Speaking of the doctrine of subrogation, Brett, L.J., said as follows in Castellane y. Preston, 1883, QBD 380, Law of Insurance 10.13. The doctrine does not arise upon any of the term of the contract of insurance, it is only another proposition which has been adopted for the purpose of carrying out the fundamental rule of indemnity, which I have mentioned, and it is a doctrine in favor of the underwriters or insurers in order to prevent the assured from recovering more than a full indemnity. It has been adopted solely for that reason. Now it seems to me that in order to carry out the fundamental rule of insurance law, this doctrine of subrogation must be carried to the extent which I am now about to endeavor to express, namely, that as between the underwriter and the assured, the underwriter is entitled to the advantage of every right of the assured, whether such right consist in contract fulfilled or unfulfilled, or in remedy for tort capable of being insisted or already insisted on, or in any other right, whether by way of condition or otherwise, legal or equitable, which can be, or has been exercised or has accrued, and whether such right could or could not be enforced by the insurer in the name of the assured by the exercise or acquiring of which right or condition the loss against is insured, can be, or has been diminished. In Scottish Union and National Insurance Company v. Davis, 1970, 1 Lloyd's Rep. 1, it was held that it is necessary for this right to arise that the insured has been fully paid. In Napier v. Hunter, 1993, AC 713, it was held that subrogation is concerned only with the loss against which the policy is addressed rather than any general loss. 4. Mitigation of loss. In case the event insured against happens, the insured must take all necessary steps to mitigate or minimize the loss as if he were not insured to preserve the property. The insured must act as a prudent uninsured person would do in similar circumstances, otherwise the insurer can avoid the payment of loss attributable to his negligence. Thus, an insured is bound to do his best under the circumstances, but he is not bound to do at his own peril. 5. Risk must attach. An agreement without consideration is void. In a contract of insurance, the insured pays the premium to the insurer for running a certain risk. If the risk is not run, the consideration for which the premium is paid fails, and therefore, the premium received by the insurer must be returned. For example, if the subject matter had already destroyed or the ship had already returned safely but both the parties are ignorant about it, the risk does not attach and the contract is thus void ab initio. 10.14 General Principles of Insurance. 6. Contribution. When the same risk and the same subject matter is insured with more than one insurer, the co-insurers, in case of loss, are liable to contribute in the proportion to the amount which each has undertaken to pay. Thus, an insurer who has paid the assured more than his share of loss is entitled to contribution from his co-insurers in proportion to the amount which each has undertaken to pay. This principle applies in case of contract of indemnity. The following are the conditions necessary for right of contribution. I. The subject matter of insurance about which claim to contribution arises must be common to all the policies, though they may include other properties. E. The peril which causes the loss must be common to all the policies, though these policies may include other perils. E. All the policies must be taken by or on behalf of the same assured. IV. All the policies must be in force at the time of the loss. V. There must not be any stipulation in the policy excluding the right of contribution. Examples: 1. Insurer A and Insurer B have independently covered a risk. If A fully indemnifies the insured, then, other things being equal, he can claim half contribution from B. 2. Insurer A and Insurer B have covered a risk. Both the policies contain the usual rateable proportion clause that the insurer will not pay more than its share of loss. If A indemnifies the insured, then B is not bound to reimburse A, because rateable proportion clause excludes the right of contribution. 7. Proximate cause 0304. Where there is a succession of causes which must have existed in order to produce the loss, or which has in fact contributed, or may have contributed to produce it, the doctrine of proximate cause has to be applied for the purpose of ascertaining which of the successive causes is the cause. Q3. What is the importance of doctrine of proximate cause in marine insurance? Explain. Al. B. D. U. Q4. Sugar barks loaded on a ship were insured against loss by seawater. A rat made a hole in the pipe of the ship. Sea water leaked through that hole into the ship and damaged sugar on the bags laying there. Whether insurance company is liable to pay this loss under policy of ship's goods? 1 LL. B. DU 1 Law of Insurance 10.15. To which the loss is to be attributed within the intention of the policy. M. N. Srinivasan, Principles of Insurance Law, 8th edition 2008, page 275. An insurer is only liable to pay for loss which has been proximately caused by a pay 5. Insured against. In Pink v. Fleming, it was held that proximate cause or causa proximo means, in law, the immediate and not the remote causes to be considered in measuring the damages. Where there is a succession of causes which must have existed in order to produce a particular result, the direct and proximate cause, i.e. the last cause, must be looked into and the others rejected, although the result would not have been produced without their concurrence. In Ley Land Shipping Company v. Norwich Union Fire Insurance Society Limited. 1918, AC 350, All 443 HL, the learned judge gave a new dimension to the concept. He explained that the proximate cause of an event is the real and efficient cause to which an event may be attributed. Where the causes are successive, the peril insured against may be the last cause for the loss, in which case it can safely be said that the loss is caused by the peril insured against. On the other hand, if the peril insured against is not the last cause for the loss but it is only a preceding cause, the question arises whether the last cause is a mere sequence of the preceding cause, the peril insured against, or was there a break in the chain of causation? If the connection between the preceding cause and the last cause is not interrupted by intervention of a fresh cause, the peril insured against will have to be treated as the real and the efficient cause, and the insurer will be liable. On the other hand, if the connection between the preceding cause and the last cause is interrupted by intervention of a fresh cause, which is not a mere reasonable and probable consequence directly and naturally resulting in the ordinary course of events from the peril insured against, the insurer will not be liable. Thus, proximate cause does not mean the nearest in time. It is the cause which is truly proximate in efficiency. It is the effective or predominant cause. It is the cause which sets the other causes in motion. The rule of causa promixa is applicable in all types of insurance contracts. To make a marine insurer liable, the insured must prove the following. A. The loss is caused by the perils of the sea. B. That the peril is one that is insured against in the policy. And C. That the peril insured against is the proximate cause for the loss sustained. 1046 General Principles of Insurance. In Pink v. Fleming, 1899-25, Q. B. D. 396 Lord Isha said, the question can only arise where there is succession of causes which must have existed in order to produce the result. There that is the cause, according to the law of marine insurance, the last cause only must be looked to and the others rejected, although the result would not have been produced without them. In this case, a cargo of oranges was insured. The peril insured was collision with another ship. The ship collided and put into port for repairs. The oranges were taken on lighter and then reloaded, which caused damage to the oranges. It was held that the proximate cause of the damage was not collision but due to mishandling while unloading and reloading of the oranges, and therefore, loss could not be recovered. In Leyland Shipping Company Limited v. Norwich Union Fire Insurance Society Limited 1918, AC 350, it was explained by the learned judge that the proximate cause of an event is the real and efficient cause to which the event may be attributed, and the application of the doctrine varies according to the question whether the loss was caused by the peril insured against. Here a ship was insured under a time policy against perils of sea, but consequences of hostilities were accepted. While on a voyage from S. America to Havre, the ship was torpedoed by a German submarine, but although she was struck forward and tended to settle down by the head, she reached Havre with the aid of tugs. There the vessel was moored in the inner harbor, where she grounded on each ebb tide and floated again on each flood, but after a few days her bulkheads gave way, and she sank, becoming a total loss. It was held that the grounding was not a new cause of the loss, but that the proximate cause was still the torpedoing, which had been expressly accepted by the terms of the policy, so that the underwriters were not liable. Lord Shaw stated that the proximate cause is the cause which is truly proximate in efficiency. The efficiency of a cause may have been preserved, though other causes in the meanwhile sprung up. If the ultimate event is the result of such an efficient cause, it will be regarded as the proximate cause, though not proximate in time. In Scaramanga v. Stamp, 1880, 5 GPD 295, a ship, which was insured against hostilities, ran on a sunken wreck of another vessel, torpedoed by an enemy submarine, which happened to be lying at the place of the accident. It was held that the insurer was not liable for their loss, as hostilities were not the proximate cause of the loss but the accident of the sunken vessel, lying at the place where it lay. On the other hand, in William and Company v. North of England Indemnity 917, K. B. 527, when an enemy had purposely sunk a vessel at the entrance of a port, in order to damage vessels entering therein, it was held that the loss was recoverable, being covered bv a similar clause as the above, in the Uli CV. Insurance 10.17. In Hamilton Fraser and Company v. Pandolf and Company 1887, 12 App. Cass. 518. The cargo, rice, was insured against damage by sea water. During the voyage, rats made a hole in a pipe which connected the bathroom with the sea, with the result that sea water got through this hole and damaged the rice. It was held that the proximate cause of damage being sea water, the insured was entitled to damages, the rats being a remote cause. In another case, where hides and tobacco were shipped in the same vessel, and the hides became polluted by reason of sea water during a storm, and the stench from them spoiled the tobacco, the damage thus caused was held as having been proximately caused by perils of the sea. In Taylor v. Dunbar, 1899-38 LJCP 178, a ship carrying meat was delayed by storm. The meat became decomposed and had to be thrown overboard. It was held that the loss of meat was not a loss by the perils of the sea, the proximate cause being delay, although the delay was caused by a peril insured against. Thus, an insurer is only liable to pay for loss which has been proximately caused by a peril insured against. The principle is most vigorously applied to contract of marine insurance where there are more chances of succession of causes leading to a loss, some of which may not be insured against. Section 55 of the Marine Insurance Act, 1963 provides that, unless the policy otherwise provides, the insurer is liable for any loss proximately caused by a peril insured against. Thus, in order to recover loss under a marine policy, the loss, I, must have arisen from any of the accepted perils, and E, the accepted perils, must be the proximate cause of the loss. It further provides that, an insurer is not liable for loss attributable to the willful misconduct of the assured, but in the absence of a contract to the contrary, he is liable for loss caused by a peril insured against, although the loss would not have occurred but for the misconduct of the master or the crew. B. Unless the contract otherwise provides, insurer of ship or goods is not liable for loss caused by delay, although the delay is caused by a peril insured against. C. Subject to the contract to the contrary, the insurer is also not liable for loss caused by ordinary wear and tear, ordinary leakage and breakage, and by inherent vice or nature of the subject matter, nor for any loss presumably caused by rats or injury to machinery not proximately caused by maritime peril. Thus, S. 55 of the Marine Insurance Act 1963 adopts the principles laid down in the aforesaid cases. In New India Insurance Company Limited, V. M. S. Zuari Industries, 2009-8, S. C. C. 70, the complainant had taken two insurance policies. One policy was fire policy and the other was a consequential loss due to fire policy. On ton or weight. 1999 at about 3.20 nanometers. There was a short circuit in the 10.18 General Principles of Insurance. Main switchboard installed in the substation receiving electricity from the State Electricity Board, which resulted in a flashover producing overcurrents. The flashover and overcurrents generated excessive heat. The paint on the panel board was charred by this excessive heat, producing excessive smoke and soot, and the partition of the adjoining feeder developed a hole. The smoke, soot along with the ionized air traveled to the generator compartment, where also there was a short circuiting and the generator power also tripped. As a result, the entire electric supply to the plant stopped, and due to the stoppage of electric supply, the supply of water, steam to the waste heat boiler by the flue gases at high temperature continued to be fed into the boiler, which resulted in damage due to fire. It was held that the fire was the efficient and active cause of the damage. Had the fire not occurred, the damage would not have occurred. There was no intervening agency which was independent source of damage. It was further held that duration of the fire is not relevant. As long as there is a fire which caused the damage, the claim is maintainable even if the fire is for a fraction of a second. 8. Utmost good faith 0506 Q707A. It is a fundamental principle of insurance law that utmost good faith must be observed by the contracting parties. Good faith forbids either party from concealing, non-disclosure, what he privately knows, to draw the other into a bargain, from his ignorance of that fact and his believing the contrary. Contracts of insurance are uberima fides, and, therefore, the insured as well as insurer owe a duty to disclose before the contract is made every material fact of which they know or ought to know. If a material fact is not disclosed by the insured, the insurers have the right at any time to avoid the contract. Similarly, if a material fact is not disclosed by the insurer, the contract can be avoided by the insured. A fact is material if it is one that would affect the mind of a prudent man even though the materiality is not appreciated by the insured. Thus, in all cases of insurance whether on ships, houses or lives, the underwriter must be informed of every material circumstance within the knowledge of the insured and that the proper Q5 contracts of insurance are uberrime fidus, elucidate with the help of judicial decisions and statutory provisions on the subject. Ul. B. Du. JQ6. Insurance is a contract based on utmost good faith, and if it is not observed, the other party may avoid the contract. Explain with the help of decided cases the scope of this duty. Ul. B. D. U. Q7. What do you understand by the statement that the contracts of insurance are contracts of uberrime fidus? Describe the extent of the assured's duty of disclose. What is the object and scope of S. 45 of the Insurance Act, 1938? Ul. B. D. L. Law of Insurance 10.19. Question is whether any particular circumstance was in fact material, and not whether the party believed it to be so. This is the position of law of insurance for centuries in England. The duty to disclose all material facts to the insurer arises from the fact that many of the relevant circumstances are within the exclusive knowledge of one party, and it would be impossible for the insurer to obtain the facts necessary for him to make a proper calculation of the risk he is asked to assume without this knowledge. Accordingly, law of insurance requires the prospective insured not merely to refrain from actively misleading the insurer, but he must also disclose all material circumstances. In the leading case, Castor v. Bohm, 1766, 3 Bur 1905, this case concerned a policy which had been taken out against the taking of a fort by a foreign enemy. Lord Mansfield said, "Insurance is a contract upon speculation. The special facts, upon which the contingent chance is to be computed, lied most commonly in the knowledge of the insured only. The underwriter trusts to his representation, and proceeds upon the confidence that he does not keep back any circumstance in his knowledge, to mislead the underwriter into a belief that the circumstance does not exist, and to induce him to estimate the risk as if it did not exist. The keeping back such circumstances is a fraud and, therefore, the policy is void. Although the suppression should happen through mistake without any fraudulent intention, yet still the underwriter is deceived and the policy is void. Because the risk run is really different from the risk understood and intended to be run at the time of the agreement. Good faith forbids either party, by concealing what he privately knows, to draw the other into a bargain from his ignorance of the fact and his believing the contrary. In London Assurance v. Mansell, 1879, 11 ch. D. 363, this case concerned life insurance policy. Jessel, Mr. observed. Whether it is life or fire or marine assurance, I take it good faith is required in all cases, and though there may be certain circumstances from the peculiar nature of marine insurance which require to be disclosed and which do not apply to other contracts of insurance, that is rather, in my opinion, an illustration of the application of the principle, than a distinction in principle. In India, the duty to disclose in the case of marine insurance is prescribed by S. 19 and S. 20 of the Marine Insurance Act, 1963. S. 19 states that a contract of insurance is a contract based upon the utmost good faith, and if the utmost good faith be not observed by either party, the contract may be avoided by the opposite party. S. 20 lays down as follows: 10.20 General Principles of Insurance. S. 20. 1. Subject to the provisions of this section, the assured must disclose to the insurer before the contract is concluded every material circumstance which is known to the assured, and the assured is deemed to know every circumstance which in the ordinary course of business ought to be known to him. If the assured fails to make such disclosure, the insurer may avoid the contract. 2. Every circumstance is material which would influence the judgment of prudent insurer in fixing the premium or determining whether he will take the risk. The provisions of Marine Insurance Act in India are in pan materia with the English Act in this respect. In Krishnavati Puri v. LIC, Air 1975 Delhi 16, it was observed that the test of what is material fact and the degree of good faith which is required is otherwise the same in all classes of insurance. The Act uses the words prudent insurer, which means that in a dispute the court must apply the objective standard of business usage and disregard the exacting standard of a particular insurer. Circumstances that need not be disclosed include those diminishing the risk and matters of common knowledge generally or on the insurer's business. The prospective assured must disclose material circumstances that he knows or ought to know. The following facts have been held to be material. 1. Facts which suggest that the subject matter of insurance is exposed to more than ordinary danger from the peril insured against. For example, in case of highly inflammable goods, the risk of loss by fire is more as compared to other goods. 2. Facts which suggest that the purpose of the assured in taking out an insurance policy is not based on good faith. 3. All facts relating to the previous history of the assured which are relevant for the contract of insurance. For example, the question whether the insurance proposal has been rejected by any other company is material. Similarly, the question whether the proposer has ever been a claimant under the insurance policy is material. Kasam Ali Bulbul v. The India Insurance Company. 4. All facts are material which the assured knows that they are regarded by the insurer as material. 5. Facts relating to serious ailment, health and habits of the assured are material. The duty of disclosure continues down to the time when the Contract Law of Insurance 10.21. Between the date of the proposal and that of final acceptance of the risk by the insurance company, that the date of the concluding of the contract, that alteration must be disclosed. Luka v. Law Union and Rock Insurance Company Limited. 1928, 1 KB, 554. In United India Insurance Company Limited. V. MKJ Corporation, 1996-6, S. C. C. 428, it was held that good faith is a continuing obligation. Even after entering into the contract, no material alteration can be made by insurer in the terms of the contract without consent of the insured. Just as the insured has a duty to disclose, similarly it is the duty of the insurers and their agents to disclose all material facts within their knowledge, since obligation of good faith applies equally with the assured. If a person fills in a proposal form for a prospective insured, he acts as the agent of the insured and not as the agent of the insurer, even if the form is filled in by an insurance agent. Thus, in Bigger v. Rook Life Assurance Company 1902, 1 KB 516, the agent filled in wrong answer, and the applicant signed without reading the proposal or checking the particulars given. Held, the applicant was guilty of non-disclosure, and the policy was void. Similarly, in Newshome Brother v. Road Transport and General Insurance Company 1929, 2 KB 365, agent was told the true facts, but for some unexplained reasons fill in wrong answers, and the applicant signed without checking what the agent had written. It was held that the insurers were not liable. In Dewsons Limited. V. Bonan, 1922-2, Ac. 413. It was held that where the terms of a policy of insurance, the proposal form is made the basis of the contract of insurance, the insurer will not be liable if any of the statements contained in the proposal form are untrue, whether they are on material points or not. In this case, a statement as to the place of garaging the lorry was untrue. The claim of the insured under the policy failed, although the statement in question was not material. Thus, by inserting this warranty of truth or basis clause in policies, insurer can save himself from the trouble of proving that untrue statement by the assured in the proposal form were material, in other words, that, but for untruth they would not have accepted the risk for the premium agreed. The courts in England tend to construe the basis of the contract clauses strictly against due insurance companies. The questions of legislating against such clauses have been considered by the Law Reform Committee, 1957 Fifth Report, but no definitive recommendation was made. In Mutual Life Insurance Company of New York v. Ontario Metal Products Company. Laid. 1925, AC 344, no basis clause was contained in the policy and the non-disclosure or misstatement was not material to the 10.22 General Principles of Insurance. Assured was asked for the name of any physician who had treated him during the last 5 years before he took out the insurance. To this be replied that he had received no treatment during the period in question, and this was obviously untrue. The result of medical examination for the insurance had revealed excellent health and therefore, had the facts concealed been disclosed, it would not have influenced a prudent insurer so as to induce him to refuse the risk or to alter the premium. Section 45 of the Insurance Act, 1938 enacts a special provision of law in this connection. The section is as follows. 45. Policy not to be called in question on ground of misstatement after 2 years. QSQ9Q9A. No policy of life insurance affected before the commencement of this Act shall, after the expiry of 2 years from the date of commencement of this Act, and no policy of life insurance affected after the coming into force of this Act shall, after the expiry of 2 years from the date on which it was effected, be called in question by an insurer on the ground that a statement made in the proposal for insurance or in any report of a medical officer, or referee or friend of the insured, or in any other document leading to the issue of the policy, was inaccurate or false, unless the insurer shows that such statement was on a material matter or suppressed facts which it was material to disclose, and that it was fraudulently made by the policyholder, and that the policyholder Q8. A, aged 48, had her attack in 2002 for which he had open heart surgery, in Lakshmi Hospital. In 2005, he insured his life with Life Insurance Corporation of India, LIC, for Rs. 500,000. In the proposal form to the question, "Have you suffered any heart ailment?" A gave a negative answer. A doctor of LIC examined the health of her, but he recommended us life to be insured. After 4 years of insurance policy, a died by another heart attack. Can Life Insurance Corporation of India refuse to pay the sum insured to the nominee of the policy? Can claimant plead estoppels and bar of Section 45 of the Insurance Act, 1938? Decide. Ul. B. Du. Q9. The assured Kundan had insured his life under a policy issued by the LIC of India on the 1st of November 2009 for a sum of 65,000 rupees. In an answer to the question in the proposal from, he had stated as follows: "Have you suffered from mental derangement within past 3 years?" Answer: no, whereas in fact he had, though not aware of the fact, been in confinement for mental derangement years ago. Kundan died on the 1st of March 2012. Sudha, wife of Kundan, claimed the amount under the policy as the person entitled to it. The LIC of India resists the claim on the ground that the assured, Kundan, concealed the material fact regarding the mental derangement at the time of the proposal. How will you decide? Discuss with reference to the statutory provisions and the case law on the subject. Ul. B. A greater than Uj Q9A. X insured his life with Birla Sun Life Insurance Company Limited. At the time of the proposal, he replied to a number of questions contained in the proposal form, including as to whether he was a graduate or not. He replied in affirmative. but in fact, he could not pass his graduation degree examination. After 3 years of this knowledge, he met with an accident and died. Kennex Law of Insurance 10.23. Knew at the time of making it that the statement was false or that it suppressed facts which it was material to disclose, provided that nothing in this section shall prevent the insurer from calling for proof of age at any time if he is entitled to do so, and no policy shall be deemed to be called in question merely because the terms of the policy are adjusted on subsequent proof that the age of the life insured was incorrectly stated in the proposal. It would be noticed that the operating part of S. 45 states in effect that no policy of life insurance affected after the coming into force of the Act shall, after the expiry of 2 years from the date on ZVHICH its hours affected, be called in question by an insurer on the ground that a statement made in the proposal for insurance or in any report of a medical officer, or referee, or friend of the insured, or in any other document leading to the issue of the policy, was inaccurate or false. The second part of the section is in the nature of a proviso. ZVHICH creates an exception. It lays DOZVN that if the insurer shows vs that such statement covers on a material matter or suppressed facts which it covers material to disclose and that it was fraudulently made by the policyholder and that the policyholder knew at the time of making it that the statement was false or that it suppressed facts which it was material to disclose, then the insurer can call in question the policy affected as a result of such inaccurate or false statement. Tier 3 conditions for the application of the second part of S. 45 as pointed out by DASSK, J. In Mata Lai Nayak v. LIC 1962-32 SC, Comp. Cas. 177, Air 1962 SC 814, the statement must be on a material matter or must suppress facts which it was material to disclose. B. The suppression must be fraudulently made by the policyholder. And C. The policyholder must have known at the time of making the statement that it was false or that it suppressed facts which it was material to disclose. The test of materiality is, therefore, superimposed by the statute on the terms and conditions of the proposal. The contractual freedom of the insurers has been severely restricted by Indian legislature. The insured has thus been sufficiently protected and the resulting contract cannot be rescinded merely upon proof that the information is inaccurate unless all the 3 conditions of S. 45 are satisfied. In this sense, Indian law is a distinct advance upon the English law. 10.24 General Principles of Insurance. Fraud means and includes any of the following acts committed by a party to a contract, or with his connivance or by his agent, with intent to deceive another party thereto or his agent, or to induce him to enter into the contract. 1. The suggestion, as a fact, of that which is not true by one who does not believe it to be true. 2. The active concealment of a fact by one having knowledge or belief of the fact. 3. A promise made without any intention of performing it. 4. Any other act fitted to deceive. 5. Any such act or omission as the law specially declares to be fraudulent. In Mata Lal Nayak v. LIC, Air 1962 SC 814, it was observed that consideration of material facts when making a proposal for insurance by one having knowledge and belief of fact would fall under S. 17 of the Contract Act and the policy issued would be vitiated thereby. Coming back to S. 45 of the Insurance Act, 1938, it has been held in Ved Mahesh Chandra v. LIC, 1968-38 Comp. Cas. 767, that the section does not apply merely because the assured died within 2 years of the date of the policy. Again in New India Assurance Company v. Sulochana Chaudhrani, 1962-32 Com. Cas. 1029 Assam, it was held that S. 45 applies also to cases where the assured dies within 2 years of the date of the policy, if the insurer seeks to avoid the policy only after the expiry of 2 years from the date of the policy. The policy does not become effective from the date the formal document is executed or issued. The phraseology used in S. 45 relates to a date from which the policy of insurance becomes effective, and such date would be the date of acceptance of the proposal from which the risk on the life of the proposer is covered. Shioshankar vs. LIC, 1973-43 Comp. Cas. 284, Bohm. In All India General Insurance Company Limited. V. S.P. Maheshwari, Air 1960 Mad. 848. It was held that the insurance company is entitled to avoid the policy on the grounds of deliberate misrepresentation about drinking habit and non-disclosure of venereal disease. Again in New India Assurance Company. V. Sulochana Chaudhrani, 1962-32 Comp. Cas. 1029, Assam. It was held that if the assured is accustomed to heavy drinking, it is a material fact. But a statement concerning the literacy of the insured or observance of _I. It. F. Zan A. Our Law of Insurance 10.25. In Mata Lal Nayak vs. LIC, A 1962 SC 814, the assured fraudulently made a false statement relating to his health. It was held that the mere fact that the insurance company had the assured examined by its own doctor will not relieve him from the legal consequences of the false statement. In Krishnawat vs. LIC of India, Air 1975 Delhi 19, it was held that the corporation was entitled to avoid the policy on the grounds available to the insurers under S. 45 of the Insurance Act, 1938, as the assured not only failed to disclose what it was material for him to disclose, but he made a false statement to the effect that he had never suffered from any disease of the heart. The Supreme Court in its decision in LIC v. Asha Goel 2001-2, S. C. C. 160, Air 2001 SC 549, analyzed S. 45 in terms of its operative points as follows. On a fair reading of Section 45 of the Insurance Act, it is clear that it is restrictive in nature. It lays down 3 conditions for applicability of the second part of the section, namely, a. The statement must be on a material matter or must suppress facts which it was material to disclose. B. The suppression must be fraudulently made by the policyholder. And C. The policyholder must have known at the time of making the statement that it was false or that it suppressed facts which it was material to disclose. Mere inaccuracy or falsity in respect of some recitals or items in the proposal is not sufficient. The burden of proof is on the insurer to establish these circumstances, and unless the insurer is able to do so, there is no question of the policy being avoided on ground of misstatement of facts. The contracts of insurance, including the contract of life assurance, are contracts uberima fides, and every material fact must be disclosed, otherwise, there is a good ground for rescission of the contract. The duty to disclose material facts continues right up to the conclusion of the contract and also implies any material alteration in the character of the risk which may take place between the proposal and its acceptance. If there are any misstatements or there is suppression of material facts, the policy can be called into question. For determination of the question whether there has been suppression of any material facts, it may be necessary to also examine whether the suppression relates to a fact which is in the exclusive knowledge of the person intending to take the policy, and it could not be ascertained by inquiry by a prudent person. In P.C. Chechko v. LIC of India, 2008-1, S. C. C. 321, Air 2008 SC 424, it was held that misstatement by itself was not material for repudiation of the policy unless the same is material in nature. but a deliberate wrong answer which has a great bearing on the contract of insurance, if discovered. 10.26 General Principles of Insurance may lead to the policy being vitiated in law. The purpose of taking a policy of insurance is not very material. It may serve the purpose of social security, but then the same should not be obtained with a fraudulent act by the insured. In Dipashri, widow of Vilas Anandrav Talpadevi. Life Insurance Corporation of India, 1984, 2, Bohm County Route 155, Air 1985 Bohm. 192, Painse, J. Said. In the first instance, there was no suppression whatsoever by the deceased. It was not necessary for the deceased to disclose trivial ailments, like fever, flu or dysentery. There is nothing to warrant the conclusion that the deceased had consulted medical practitioner within 5 years prior to the taking out of the policy. The concept of consultation with medical practitioner is entirely different from securing medical certificate on the ground that the person is down with fever. The perusal of the proposal form leaves no manner of doubt that it is not each and every petty ailment which has to be disclosed by the proposer, and what it required to be disclosed is a serious ailment. The deceased was not suffering from any serious ailment and was a young man of 41 years age at the time of taking out the policy. The medical practitioner on the panel of the corporation had examined him, and in these circumstances, it is futile for the corporation to claim that the deceased was suffering from any serious ailment. In my judgment, the non-disclosure of the fact that the deceased was suffering from fever or down with flu on some occasions is not a material matter, and, therefore, the failure to disclose the same cannot be construed as suppression of the relevant fact. As laid down by the Supreme Court, it is not suppression of the fact which is sufficient to attract second part of S. 45 of the Insurance Act, but what is required is that such suppression should be fraudulently made by the policyholder. The expression, fraudulently, connotes deliberate and intentional falsehood or suppression, and some strong material is required before concluding that the policyholder had played fraud on the corporation. In Life Insurance Corporation of India vs. SMT. G. M. Channabasama, 1991-1, S. C. C. 357, it was held that the burden of proving that the insured had made false representation and suppressed material facts is undoubtedly on the insurer. If the insurer fails to discharge this burden, the life insurance policy cannot be called in question by the insurer. In Life Insurance Corporation of India vs. Ajit Gangadhar Shanbhag, Air 1997 Cant 157, the Karnataka High Court held that when there is no violation of any statutory duty on the part of the corporation, and in view of the fact that the matter arises out of a contract between the insurer and Law of Insurance 10.27 insured, and there being several disputed questions of fact, a writ cannot be issued. J. In Life Insurance Corporation of India vs. Asha Goel, Air 2001 SC 549, it was held that the insured remains duty-bound to disclose any material alteration in the character of the risk, which might occur in the period between the proposal and its acceptance. Titus, the duty to disclose facts continues right up to the conclusion of the contract. It was further held that ordinarily the High Court should not entertain a writ petition filed under Article 226 of the Constitution for a mere enforcement of a claim under C. P, where claim by an insured or a nominee in a serious dispute and the court finds one which requires oral and documentary fill square n, then the appropriate remedy is a civil suit under Article 226 of the Constitution. Similarly, add by the insurer and on examination is found in oral and documentary evidence may become contract of insurance. The pros and cons of the matter in the context of the facts and situation of the case should be carefully weighted and appropriate decision should be taken. IR greater than is repudiated by the INS. The dispute to be a bevidence for its determi and not a writ PC where a plea of Fr. Prima facie have necessary for determination of the issue raised, then writ petition is not an appropriate remedy. Recasting of Section 45 suggested. The Law Commission of India has, in a working paper, suggested in April 1985 that Section 45 of the Insurance Act, 1938 should be recast to reconcile the right of the insured or claimant by pre-empting a challenge on frivolous grounds, and the right of the insurer to repudiate the claim on good grounds only. Under the English common law, contracts of insurance are contracts uberrima fides or contracts of utmost good faith, so that, if the insured makes incorrect statements or suppresses facts, the insurer is not bound to honor the contract even after the policy has been in force for several years. In the event, all premium paid would be forfeited to the insurer. Section 45 of the Insurance Act, 193(8) was enacted to modify the said rule and to mitigate the rule of utmost good faith. The Commission, after examining the various case laws on the subject and the law as it stands in the UK and the USA, has stated that the section should be recast as follows. Section 45. Policy not to be called in question on ground of misstatement after 3 years. 1. No policy of life insurance shall be called due. So general principles of insurance in question after the expiry of 3 years from the date on which the policy is effected. 2. A policy of life insurance may be called in question at any time within 3 years from the date on which the policy is effected on ground that any statement being a statement material to the expectancy of the life of the insured was incorrectly made in the proposal or other document on the basis of which the policy was issued or revived. 9. Interpretation of liability clauses in favor of ln Shoddy Q9B Q9C. Each term in the policy and each phrase in the policy is prima facie to be construed according to its ordinary meaning. Construction depends not upon the presumed intention of the parties but upon the meaning of the words used. The ordinary meaning of the word is not to be discarded for some hidden meaning. The courts will try to ascertain the meaning of the words used by adopting ordinary rules of construction. The words in the policy must not be used with extreme liberalism, but with reasonable latitude and at the same time to give effect to all the conditions and stipulations. As the object of the parties is to enter into a contract of insurance, any construction which defeats this objective is not to be followed. As the illiteracy is high in India as compared to Western countries, the principles of construction should not be applied with the same amount of strictness as in Western countries. The following points should be kept in mind while interpreting an insurance policy. 1. Intention. It is commonplace that it is the court's duty to give effect to the bargain of the parties according to their common intention. While construing an insurance policy, the intention of the parties must prevail. The intention of the parties is to be gathered from the words used in the policy. All the clauses of the policy must be looked into and not only a particular clause. In United Indian Insurance Company Limited v. Harchand Rai Chandanlal, 2004-8, S. C. C. 644, it was held that terms of the policy shall govern. Q9b. Analyze the principles of construction, interpretation of insurance policies. Ul. B. Du. Q9c. 1 Bank, P took 2 insurance policies with Oriental Insurance Company Limited. One was a cash insurance policy and the other a burglary insurance policy for Rs. 25 lakh, covering a period of 1 year. During the currency of the policies, bank was burgled one night and the cashier's cash chest was found missing. The bank reported the matter for the value of pledged jewelry in the stolen cash box along with Rs. 10,000 in cash. The insurance surveyor reported that the jewelry had not been kept in a safe locker and so the theft was not covered under the policy. The records show that in the insurance proposal from, the bank had answered in the affirmative to the question whether all valuables were secured in burglary-resisting safes when the premises are locked. The insured disclaimed liability. Decide. Ul. B. Du, Law of Insurance 10.29. The contract between the parties and they have to abide by the definition given therein, and all those expressions appearing in the policy have to be construed as it is and something cannot be added, subtracted or substituted. The parties cannot rely on the definition given in other enactments. It was held in this case that definition of burglary in criminal law was held to be of no help to the insured as it was defined in the policy as theft preceded by use of force or violence. Theft not so preceded was held not covered by policy. 2. Construction according to ordinary meaning. A policy is to be construed according to the same rules of construction, which are applied by English court to the construction of every other mercantile instrument, West Indian and Panama Telegraph Company. V. Home & Co. Ionian Marine Insurance Company. 1880, 6 QBD 51. The rule of construction is, except where words have acquired special, conventional meaning, namely what do the words mean on fair reading, having regard to the whole documents, Nelson Loan v. James Nelson and Sons. Where the language of the policy is clear, the full effect must be given to it, although it may operate harshly against the assured. Tire condition or warranty must be interpreted according to the natural meaning of the words used in the policy. In Parameshwari v. Nihal Chand, Air 1938 Sindh 20, it was held that if a clause is in small print and is such that no reasonable man reading with reasonable care would regard it as forming part of the contract will not be enforceable. In Harris v. Poland, Q1 degree 1941, 1, K, B, 462, the plaintiff took a Lloyd's, Pusholders comprehensive policy, of insurance with the defendant, insuring contents of her flat including jewelry, against loss or damage caused, inter alia by fire. For purpose of protection against theft, on leaving her flat one day, she concealed the jewelry in the grate under coal and wood, which were ready for lighting. On returning in the evening she inadvertently lit the fire and the jewelry was damaged. The question before the court. Q10. A lady X, aged 68, very nervous about the safety of her costly jewelry, insured it for Rs. 90,000 against theft and fire with a B insurance company. One day, while gone out, X kept the jewelry in the grate under coal which was ready for lighting up. On return, and mind he about the jewelry, she lit the grate which resulted in total destruction of the insured jewelry. X's claim under the policy has been subjected by the AB Insurance Company on the ground that the insurance policy destruction of tire jewelry by fine RE at a place where no fine ate to be and, moreover, jewelry was destroyed due to the gross negligence of policyholder X. Discussed principles of interpretation which should be applied in deciding the claim of X and decide whether X's claim has been nightly rejected by the company. 10.30 General Principles of Insurance. Was whether there was a loss by fire within the meaning of the policy. Where the damage was done to the insured property in place where the fire was intended to be. It was held that the risk against which the plaintiff is insured include the risk of insured property coming unintentionally in contact with fire and being thereby destroyed or damaged, and it matters not whether fire comes to the property or insured property comes to the fire. The words of the policy are as descriptive of one as the other, and the Honorable Judge said, I cannot read into the contract a limitation which is not there. To enable me to accept the contention of the underwriters, I should have to read something into the contract, some words as, unless the insured property comes into contact with fire in a place where fire is intended to be. 3. Ambiguity in the language of the policy, contra proferentum, as a policy is prepared by the underwriters, any ambiguity therein must be taken most strongly against the underwriters by whom it has been prepared. If a policy is reasonably susceptible of two constructions, that one will be adopted which is more favorable to the insured. Anderson v. Fitzgerald, 18534, H. L. C. 484. Cooperative Assurance Company v. Sachdeva, Air 1936 La. 685. Baxendale v. Harvey 1859-28 LJEXCH. 236. Harris v. Poland 1941-69, Ulkep. 35 kilobytes. The warranties particularly are to be read liberally in favor of the assured and against the insurance company. In the Central Bank of India vs. the Hartford Fire Insurance CA. Limited. Air 1965 SC 1228, it was held that contra preferentum rule had no application in that case as there was no ambiguity. In Joel v. Law Union and Crown Insurance Company 1908, 2 KB 863, it was held that rule of contra preferentum is applicable equally whether the contracts are fire, marine or life insurance. In United India Insurance Company Limited v. Pushpale Printers 2004 3 S C C 694 Air 2004 SC 1700, it was held by the Supreme Court that it is a settled law that if there is any ambiguity or a term is capable of two possible interpretations, one beneficial to the insured should be accepted consistent with the purpose for which the policy is taken, namely to cover the risk on the happening of a certain event. In this case the word impact in the instant policy was construed against the appellant. 4. Effusdum generis rule. It is well-known rule of construction that where a particular, not heterogeneous collection of items, enumeration is followed by such words as, and others, or, etc. Law of Insurance 10.31. Then such expressions are usually limited to matters easdem generis with those specifically enumerated. 5. Incorporation of proposal form and statements in policy, where the proposal form or answers in the declaration form are declared on the basis of the contract, they will form part of the contract. However, in case of inconsistency between the proposal form and the policy would prevail. Leading cases. Nezo India Insurance Company Limited v. Mies Zuari Industries Limited 2009, 8 SCC 70. Note, this case deals with the principle of proximate cause and interpretation of fire policy. Facts. The complainant, respondent in this case, had taken two insurance policies, one policy was a fire policy and the other was a consequential loss due to fire policy. On January 8, 1999 at about 3:20 p.m. there was a short-circuiting in the main switchboard installed in the substation receiving electricity from the State Electricity Board, which resulted in a flashover producing overcurrents. The flashover and overcurrents generated excessive heat producing smoke and soot and the partition of the adjoining feeder developed a hole. The smoke, soot along with the ionized air traveled to the generator compartment where also there was short-circuiting and the generator power also tripped. As a result, the entire electric supply to the plant stopped and due to the stoppage of electric supply, the supply of water, steam to the waste heat boiler by the flue gases at high temperature continued to be fed into the boiler, which resulted in damage to the boiler. The complainant approached the insurance company informing it about the accident and making its claim. The insurance company contended that the loss to the boiler and other equipments was not caused by fire, but by stoppage of electric supply due to short-circuiting in the switchboard. Issue: whether the flashover and fire was the proximate cause of the damage in question? Decision of the Supreme Court. The court held that it is evident from the chain of events that the fire was the efficient and active cause of the damage. Had the fire not won U. 32 General Principles of Insurance occurred, the damage also would not have occurred and there was no intervening agency which was independent source of damage, Markendey Katju, J. Further said, in our opinion the duration of the fire is not relevant. As long as there is a fire which caused the damage, the claim is maintainable even if the fire is for a fraction of a second. The term fire in clause 1 of the fire policy C is not qualified by the word sustained. It is well settled that the court cannot add words to statute or to a document and must read it as it is. Hence repudiation of the policy on the ground that there was no sustained fire, in our opinion, is not justified. Simond vs. Kokal, 1920, Cri. 1 KB 843. Note, the case is on ambiguity rule of construction. Facts. The plaintiff's premises were insured against loss or damage by, inter alia, burglary, house breaking or theft. The policy contained the following clause, warranted that the said premises are always occupied. The plaintiff and his wife and no other person resided at that place, which was used as a shop also. On Sunday, June 21, 1919, during the currency of the policy, the plaintiff and his wife left the premises unattended between 2:30 p.m. and 11:30 p.m. except for a short interval between 6 p.m. and 7 p.m. when the plaintiff was on the premises. On the return of the plaintiff and his wife, it was found that during their absence the premises had been broken into and some of the contents of the value of £400 had been stolen. The defendant insurer refused their liability. Decision. It was held that the words, premises are always occupied, does not mean that premises are never to be left unattended. It means that premises are to be used continuously and without interruption, for occupation, that is to say as a residence, and not merely as a lock-up ship which is left unoccupied after business hours. It was observed that it is a well-known principle of insurance law that if the language of a warranty in a policy is ambiguous, it must be construed against the. Q11. Reena has an insurance policy against theft and house breaking, with a condition that her house shall always remain occupied. The house was left unattended on one Sunday between 2 p.m. and 7 p.m., when she had gone to see her ailing mother. On her return she found the locks of her safe broken and her jewelry worth Rs. 20,000 missing. Reena claims the loss under the policy from the insurer. Decide, stating the principles of interpretation of insurance policy with reference to decided cases, if any. Ul. B. Du, Law of Insurance 10.33. Underwriter who has drawn the policy and inserted the warranty for his own protection. The court said, if the premises are used for residential as well as for business purposes, it is obvious that a thief would never know at what moment the occupation which the warranty requires and which has been secured. The defendant has not stipulated for the continuous presence of someone in the premises, which he could have done by providing that the premises were never to be left unattended. There must therefore be judgment for the plaintiff. Harris v. Poe, and Q12 feet Q13, Q14, Q15 1941, 1 KB 462. Note, the case deals with the proper construction of the words, loss by fire. Facts. The plaintiff took a Lloyd's Householders Comprehensive Policy of insurance with the defendant and other underwriters, insuring the contents of her flat, including jewelry, against loss or damage caused, inter alia, by fire. For purposes of protection against theft, on leaving her flat one day, she concealed the jewelry in the unlighted grate under coal and wood, which were ready for lighting. On returning in the evening, she inadvertently lit the fire and the jewelry was partly destroyed and partly damaged. The underwriters repudiated liability, contended that the loss was not covered since it did not fall within the terms of the policy, which only applied to loss or damage caused by fire, because the damage had been done to the insured property by fire in a place where it was intended, i.e., in the grate. On the other hand, it was contended on behalf of the insured, plaintiff, that the indemnity in the policy is against any loss or damage by fire to the property. The fact that the plaintiff in ignorance caused the loss does not affect it. Q12. State the facts of Harris vs. Poland, 1941, all 204 and explain the rules applied for proper construction of the phrase, loss by fire, in a fire insurance policy. Ul. B. Du. Qi3. State the main rules of construction of an insurance policy, elaborating how the judiciary applied their ruler in the case of Harris v. Poland, 1941, all 204. Ul. B. Du. Q14. A took a comprehensive policy of insurance with Company B, ensuring the constant of her flat, including jewelry, against loss by theft. On leaving her flat one day, she cancelled the jewelry in the grate under coal and wood, which was ready for lighting. On returning in the evening, she inadvertently lit the fire, and the jewelry was damaged. Decide with the help of case law. Ul. B. Du. 10.34 General Principles of Insurance. Issue. Whether there was a loss by fire within the meaning of the policy, where the damage was done to the insured property in a place where the fire was intended to be. Decision. T was held that it mattered not whether the property had gone to the fire or the fire had gone to the property. There had been ignition of insured property not intended to be ignited, and the loss falls within the plain words of the policy. In the course of his judgment, Atkinson J. said, I have no doubt that the ordinary man, when insures against loss by fire, believes that he is insuring against every kind of loss which he may suffer from the more or less compulsory use of fire by himself or his neighbor. His lordship said in the textbooks there is no clear consensus as to the meaning of the words, loss or damage caused by fire, which might force him to hold that they have acquired a recognized meaning to which one can give effect. There is difference of opinion or ambiguity in the textbooks. And ambiguity is fatal to the underwriter's case, as in case of ambiguity the interpretation most favorable to the insured must be adopted. If there is no ambiguity, each term in the policy and each phrase in the policy prima facie to be construed according to its ordinary meaning and not upon the presumed intention of the parties. Guided by these principles, his lordship said, in my judgment, the risks against which the plaintiff is insured included the risk of insured property coming unintentionally in contact with fire and being thereby destroyed or damaged, and it matters not whether that fire comes to the insured property or the insured property comes to fire. The words of the policy are just as descriptive of one as the other, and I cannot read into the contract a limitation which is not there. To enable me to accept the contention of the underwriters, I should have to read something into the contract, some such words as, unless the insured property is burned by coming in contact with fire in a place where fire is intended to be. The test of liability according to Holt's reports referred to in the case is this: has something been consumed by fire which was not intended to be consumed? If the fire is cause of the damage, it matters not whether the fire was properly or improperly lighted, but the question is whether the fire occasioned the damage. Atkinson J. based his views in substance on what Biles, J. said in Everett v. The London Assurance, 19 CB, NS, 126. In this Raspit-Wack Law of Insurance 10.35. Construed as ordinary people would construe them. They mean loss or damage either by ignition of the article consumed or by ignition of part of the premises where the article is. In the one there is a loss, in the other damage caused by fire. Atkinson J. said, I think there is loss or damage caused by fire, so there has been ignition of insured property which was not intended to be ignited, or when insured property has been damaged otherwise than by ignition as a direct consequence of the ignition of other property not intended to be ignited. Notes: a fire policy protects the assured against fire. There is no fire unless there is ignition. Mere heating, however intense, is not fire. Loss or damage caused by fire means loss or damage either by ignition of the articles consumed, or by ignition of that part of the premises where the article is. In one case there is loss, in the other case there is a damage caused by fire. The cause of the fire is immaterial, unless it was the deliberate act of the assured. Fire may be caused by the negligence of the assured himself or his servants. Fire does not include explosion. If, however, the explosion is caused by fire or if explosion causes fire which causes the loss is covered. Same is the case with lightning and electricity. Any loss resulting from apparently necessary and bona fide efforts to put out a fire, whether it be the spoiling goods by water or by throwing articles of furniture out of the window, or even by destroying a neighboring house by explosion for the purpose of arresting fire. In fact, every loss directly, if not indirectly at least consequently resulting from fire is within the policy. Stanley v. Western and Stirrance Company. 1868, 37 LJX. 73, at page 75 per Kelly, C.B. In Austin v. Drew. 1815, 4 Camp. 360, sugar was damaged not by smoke but by the excessive heat but nothing took fire. It was held that assured could not recover. It may be noted here that if the heat is caused by actual ignition of the premises where the sugar is kept, the damage shall be deemed as damage by fire, although the sugar is not actually burnt. The Central Bank of India Limited. v. The Hartford Fire Insurance Company Limited. Air 1965 SC 1228. Note: a clause in a policy terminating the policy at any time by either party is valid. Facts: by a policy, the respondent insurance company insured the appellant as the mortgagee and a firm of the name of Bombay Import and Export Agency as the owners against loss suffered by destruction of or damage. 10.36 General Principles of Insurance. Fire between March 20, 1947 and March 20, 1948. The insurance was subject to various conditions and one of them, Clause 10, was that this insurance may be terminated at any time at the request of the insured, and this insurance may also at any time be terminated at the option of the company. Insurer, no notice to that effect being given to the insured, in which case the insurance company shall be liable to repay on demand a rateable proportion of the premium for the unexpired term of the policy. By mutual agreement, the policy was extended to cover riot risks occurring between July 18, 1947 and August 17, 1947. From early 1947, the whole of the Punjab, including the town of Amritsar, was disturbed by serious riots which preceded the partition of India. On or about July 23, 1947, some of the insured goods were looted. The information of it was given to the insurance company, and thereafter on August 7, 1947, the insurance company served a notice to the insured that goods lying in the godown at Bakarwana Bazaar, Amritsar, be removed to a safe locality before the 10th of August 1947, otherwise the policy would stand terminated at 4 p.m. on the 10th of August 1947. The insured did not remove the goods to any other place by the stipulated time and were lost as the godown was burned down by rioters on August 15, 1947. Insured claimed damage which the insurance company refused. Hence the action. On behalf of the insured, it was contended, that policy could be terminated only for a reasonable cause. That the clause 10 was unreasonable. That there being ambiguity, the clause be interpreted in favor of the insured. And that the insurance company could not avoid liability by termination. Issue: whether the policy had been terminated on August 10, 1947. Decision of the Supreme Court regarding intention of the parties and the interpretation of the impugned Clause 10 of the Contract of Insurance Sarkar, J. said, now it is commonplace that it is the court's duty to give effect to the bargain of the parties according to their intention, and when that bargain is in writing the intention is to be looked for in the words used unless they are such that one may suspect that they do not convey the intention correctly. If these words are clear, there is very little that the court has to do. The court must give effect to the plain meaning of the word, however it may dislike the result. We have earlier set out Clause 10 and we find no difficulty or doubt as to the meaning of the language there used. Indeed, the language is the plainest. The clause says, this insurance may law of insurance 10.37. May also at any time be terminated at the instance of the company. These are all the words of the clause that matter for the present purpose. The words, at any time, can only mean, at any time the party concerned likes. Shortly, Clause 10 says a party at its will can terminate the policy. No other meaning of the words is conceivable. The plain and categorical language cannot be radically changed by relying upon the surrounding circumstance. A right to terminate at will cannot by reason of the circumstances be read as a right to terminate for a reasonable cause. There is no ambiguity in the words used or defect in the operation of the instrument. The court said there is nothing capricious or unreasonable in Clause 10. It sanctions no repudiation of liability already incurred but only terminates a contract as to future. It prevents liability arising in future, which is not a fundamental term of the contract. Clause 10 gives the liberty to terminate the policy to both the parties. Clause 10 was in effect a proviso to the term fixing the tenure of the policy at 1 year. The court said, we are besides of the opinion that there is nothing capricious or unreasonable in Clause 10. The insurer was free at the beginning to decide whether he would agree to indemnify the assured against the risk or not, and if he decided to indemnify, for how long he would indemnify. If the assured cannot compel an insurer to take up a risk, he cannot complain of unreasonableness, caprice, or even abuse of power if the insurer is prepared to take it up only on a condition that he would be free at any time to change his mind as to the future. Furthermore, Clause 10 gives the assured the same liberty to terminate the policy. Besides, a term in the form contained in Clause 10 is a common term in policies and must, therefore, have been accepted as reasonable. See McGillivray on Insurance Law, 5th ed. Vol. 2 p. 963. The Privy Council in the Sunfire Office v. Hart, 1889-14, Ac. 98, held of a clause similar to Clause 10 in the present case, that it gave an insurer the right to terminate the contract at will, and that there was nothing absurd in such a term. Regarding the rule of contra proferenturn, it was held that this rule should be applied only where there is ambiguity in the terms bid. The rule has no application where there is no ambiguity in the z-words in the standard form contract. The court also rejected the argument that it was impossible to remove the goods from the go-down at Bakarwana Bazaar to any other safe place in the same town in the circumstances prevailing. It said if a party has a right will to terminate a contract, the imposition by him of a condition, however hard, on failure to fulfill which the termination was to take effect, would not make the termination illegal. 10.38 General Principles of Insurance. Titus, the court held that the insurance company had power under Clause 10 of the policy to terminate the contract at will, and it had only exercised that power. Castelling vs. Preston. 1883, 11 QBD 380. Note, the case deals with the rule of indemnity and subrogation. Facts. The defendants assured owned certain premises in Liverpool, and in March 1878, they effected an insurance on buildings against loss by fire with an insurance company. The policy was in the usual form, giving the insurers the option of reinstating the property. In July 1878, the defendants agreed to sell the premises for £3,100 and received some money as deposit. The contract was to be completed on a day within 2 years to be named by the defendants. In August 1878, a fire occurred which damaged part of the buildings, and a claim was agreed at £330. The insurers paid the sum to the defendants, assured, in ignorance of the contract made for the sale of the property. The contract for sale was eventually completed in December 1879, and the balance of the purchase money was then paid to the defendant, assured, by the purchasers. The insurance company claimed to be repaid by the defendants, respondents assured, the sum of £330 paid by them, on the ground that a contract of fire insurance was a contract of indemnity and that in the circumstances the defendants, assured, had not lost anything in fact, because the contract of sale of property had been duly completed, and the defendants had suffered no loss by fire. And the insurance company also claimed to be subrogated to the rights of the defendants, under that contract of sale, to the extent of the sum of £330. In the trial court, Chitty, J. gave judgment for the defendants, and the insurance company then appealed. Decision of the Court of Appeal. The court upheld the contentions of the insurance company and allowed it to claim £330 on the ground of doctrine of indemnity and subrogation. Speaking of indemnity, Brett, L.J., said, "The very foundation, in M.V. opinion, of every rule which has been applied to insurance law is this, namely, that the contract of insurance contained in a marine or fire policy is a contract of indemnity, and of indemnity only, and that contract means that the assured, in case of any loss against which law of insurance 10.39 the policy has been made, shall be fully indemnified, but shall never be more than fully indemnified." Speaking of the doctrine of subrogation, he said, "That doctrine does not arise upon any terms of the contract of insurance. It is only another proposition which has been adopted for purpose of carrying out the fundamental rule which I have mentioned, and it is a doctrine in favor of the underwriters or insurers in order to prevent the assured from recovering more than a full indemnity. It has been adopted solely for that reason. Now it seems to me that in order to carry out the fundamental rule of insurance law, this doctrine of subrogation must be carried to the extent which I am now about to endeavor to express, namely, that as between the underwriter and the assured, the underwriter is entitled to the advantage of every right of the assured, whether such right consist in contract, fulfilled or unfulfilled, or in remedy for tort capable of being insisted or already insisted on, or any other right, whether by way of condition or otherwise, legal or equitable, which can be or has been exercised or has accrued, and whether such right could not be enforced by the insurer in the name of the assured, by the exercise or acquiring of which right or condition the loss against which the assured is insured, can be, or has been diminished." Notes 1. The indemnity and subrogation principles forbade the vendor of insured premises in the above case to keep the insurance payment and the full purchase price. But in this type of case, the insurance company need pay no indemnity for a loss it covered, and for which it received premiums, and the loss instead falls on the purchaser. Therefore, to protect himself, the purchaser of a movable property should insure it in his own name. 2. In page V. Scottish Insurance Corporation, 1929, 98 LJ, KB 308, it was decided that the right of subrogation only arises when the insurer has actually paid the loss. In case of subrogation, the underwriter cannot sue in his own name. His rights are the rights of the assured. The underwriter has no right to subrogation unless and until he fully indemnifies the assured under the policy. The right arises on payment of the whole loss. If the property is insured for less than its actual value, the insurer will not enjoy this right on payment of the policy amount. 3. In Yorkshire Insurance Company Limited. V. Nisbat Shipping Company Limited. 1961, 2 All ER 487. It was held that subrogation does not mean that the insurer can compel the assured to pay over more than he was paid under the policy. Tire assured can keep windfalls. In this case, a ship, insured for $72,000, was lost following a collision with Canadian VPECO IR greater than RLFHO 10.40 General Principles of Insurance. The Canadian owners, the assured, recovered the value of the ship in Canadian currency, some $36,000. Meanwhile, however, the pound sterling had been devalued, so that the dollars, when remitted to Britain, yielded some $126,000. The assured repaid the insurers $72,000 received earlier under the policy, but the insurers claimed that under the doctrine of subrogation they were also entitled to the windfall of $54,000. The court rejected the contention of the insurer. Pink and others v. Fleming 1899-25 QBD 396. Note: the case explains the doctrine of causa proxima in marine insurance. Facts: a cargo of oranges was insured, free from particular average, unless the ship be stranded, sunk or burnt, or unless damage be consequent on collision with any other ship. The ship collided and put into port for repairs. A portion of the oranges and lemons were taken on lighters and then reloaded. When the ship arrived at the port of discharge, a portion of the fruit had gone bad. The evidence showed that the damage had been partly caused by the delivery and partly by the handling of the fruit, which necessarily took place in discharging and reshipment of it for the purpose of the repairs. Decision: it was held that the proximate cause of the loss was not the collision or any peril of the sea. It was the perishable character of the articles combined with the handling in one case and the delay in the other, which caused the damage. Hence the underwriters were held not liable. As per Lord Eisher, MP. The judgment is as follows. It is well settled that by the law of England there is a distinction in this respect between cases of marine insurance and those of other liabilities in cases upon the proximate cause of the loss. In the case of an action for damage of which the breach is an efficient cause or cause causens. But in cases of marine insurance only the proximate cause can be regarded. This question can only arise where there is a succession of causes which must be existed in order to produce the result. There that is the cause, according to the law of marine insurance, the last cause only must be looked to and the others rejected, although the result Z would not have been produced Z without them. Here there is such a succession of causes. First there was the collision. Without that no doubt the loss would not have happened. But would such loss have resulted from the collision alone? Is it the natural result of a collision that the ship should, law of insurance 10.41, be taken to a port for repairs, and that the cargo, being of a kind that must be injured by handling, it should be injured in such removal? A collision might happen without any of these consequences if it had not been for the repairs and for the removal of the cargo for the purpose of such repairs and for the consequent delay in handling of the fruits, the loss would not have happened. The collision may be said to have been a cause, and an effective cause of the ship's putting into a port and of repairs being necessary to remove the fruit, and such removal necessarily caused the damage to it. The agent, however, which proximately caused the damage to the fruit, was the handling, though no doubt the cause of the handling was the repairs, and the cause of the repairs was the collision. According to the English law of marine insurance only the last cause can be regarded. There is nothing in the policy to say that the underwriters will be liable for loss occasioned by that. To connect the loss with any peril mentioned in the policy, the plaintiffs must go back 2 steps, and that according to English law, they are not entitled to do. Mithulal Nayak v. Life Insurance Corporation of India. Air 1962 South Carolina 814. Note: The case deals with the deliberate suppression of material facts. Facts: in 1942, one Mahajan Deol sent a proposal for the insurance of his wife. He was examined by Dr. D. Desai, who submitted two reports, one with the proposal form and one confidential report. The confidential report showed that Mahajan Deol was anemic, had a dilated heart, and his right lung showed indications of an old attack of pneumonia or pleurisy, and that he was a total physical wreck. Nothing came out of this proposal and it lapsed. In 1943, Mahajan Deol consulted and was treated by one Dr. P.N. Lakshmanan, consulting physician at Jabalpur, for anemia, edema of the feet, diarrhea and fainting on exertion. In 1944, Mahajan Deol made a fresh proposal for insurance of his life. Against the question in the proposal form whether he had consulted any medical man for any ailment within the last 5 years, he gave the answer, no. He also did not disclose any of his ailments. After medical examination by one Dr. Kapadia, the proposal was accepted and a policy for Rs. 25,000 issued on March 13, 1945. The policy lapsed for non-payment of premium but was received in July 1946. In November 1946, Mahajan Deol died. His assignee, the appellant, made a demand for Rs. 26,000, but the company on OCT 1, 1947, repudiated it on the ground that the policy had been obtained BV Deliberate Misstatement 10.42 General Principles of Insurance and fraudulent suppression of material facts. Thereupon, the appellant filed a suit to recover the amount of the policy, contending that S. 45 of the Insurance Act, 1938, barred the company from calling in question the policy after 2 years on the ground that any statement made in the proposal was inaccurate or false. Decision. It was held that the insured, Maheen Denial, was guilty of fraudulent suppression of material facts relating to his health, and the company was entitled to avoid the policy under S. 45 of the Insurance Act, 1938. It was observed that in view of the language of the section, 2 years could not be counted from the date of the revival of the policy. Thus, S. 45 was applied to the case as 2 years had elapsed since the policy was effected. The court said that second part of S. 45 entitled the company to repudiate the contract even after the expiry of 2 years if 3 conditions were fulfilled, viz. 1. The statement was on a material matter or there was a suppression of fact which was material to disclose. 2. The suppression was fraudulently made by the policyholder. And 3. The policyholder must have known at the time of making of the statement that it was false or that it suppressed facts which it was material to disclose. When Mahajan Deol was treated in 1943 by Dr. P.N. Lakshmanan, he was suffering from serious ailments. He must have known that it is material to disclose this, but made false statement that he had not been treated by any doctor for any serious ailment. There was deliberate suppression of material facts fraudulently made by Mahajan Deol. Even though the company had got Mahajan Deol examined by 4 doctors before issuing the policy, it was not stopped from questioning the policy. It had no means of knowledge that Mahajan Deol had been treated by Dr. P.N. Lakshmanan for serious ailments. It was further held that the appellant was not entitled even to a refund of the money paid as premium, as one of the terms of the policy was that all monies paid belonged to company if the policy was vitiated by fraudulent suppression of material facts. To such a contract neither S. 65 nor S. 64 of the Indian Contract Act had any application. It was also held that the assignee had no insurable interest in the life of the assured and cannot sue on the policy. As the title of the assured was defective, he cannot transfer a better title to the assignee. Law of Insurance 10.43 Sint. Krishnajoti Puri v. LIC of India Air 1975 Delhi 19. Note: the case deals with the non-disclosure of material matter. Facts: Dharampal Puri insured his life with the Life Insurance Corporation and took out 4 policies between the 12th of October 1959 to the 15th of June 1964, amounting in aggregate to Rs. 85,000. He died on the 5th of August 1964. His widow, the plaintiff appellant, instituted the suit against the corporation on the ground that she was the assignee. The corporation resisted the suit mainly on the ground that Dharampal Puri was suffering from heart disease, that he knew about his ailment, that he had consulted doctors about his disease but fraudulently suppressed these facts. In the proposal form and the personal statements he made declarations knowing them to be false because he never disclosed to the corporation that he was suffering from heart disease. On evidence it was found that Dharampal Puri had suffered from heart diseases, consulted doctors but did not disclose this in the proposal form or his personal statement, although 3 doctors who examined Dharampal Puri deposed that in their opinion the deceased was fit to be insured at the time of their examination. Decision: it was held that non-disclosure of heart disease was a material matter and that the insured, Dharampal Puri, had fraudulently suppressed the fact which was material to be disclosed, and he knew the statements to be false when he made them. It was further held that the fact that the insured was examined by 3 doctors of the corporation and that they deposed that in their opinion the person was fit to be insured at the time of their examination did not advance the claim of the plaintiff claimant. The corporation did not know that there was a fraudulent suppression of facts and that the material statements made by the insured in the proposal were the basis on which the policy was issued. Thus, it was held that the corporation was entitled to avoid the claim on the policy under S. 45 of the Insurance Act, 1938. 10.44 General Principles of Insurance. Manohar Lal V. LIC of India. Air 1981 Delhi 171. Note: the case deals with the meaning of material matter. Facts: the plaintiff Manohar Lal took a joint life policy on his life and the life of his wife, Sita Rani, from Sunlight of India Insurance Company Limited on May 23, 1956 for a period of 25 years in the amount of Rs. 25,007. He paid the annual premium of the Rs. 906. The term of the policy was that in the event of death of either of them before the date of maturity, the sum assured was payable to the survivor. Sita Rani died on June 22, 1957. The plaintiff made a claim on the defendant, Life Insurance Corporation of India, which took over the assets of the Sunlight Insurance by virtue of Act 31 of 1956. 1956. The corporation repudiated the claim on the ground that the plaintiff was guilty of fraudulent misrepresentation. In the proposal form which the plaintiff filled up, the question put to him was to state his C.I. profession, E. exact nature of duties. The answer of the plaintiff was tutor and photographer. The plaintiff was in fact working as a laborer in Birla Cotton Mills at a monthly salary of Rs. 120. Decision: it was held that the wrong description of occupation in the proposal for insurance would not avoid the policy. The plaintiff would have been insured at the same rate of premium had he described himself as a factory hand or a mill worker. The same premium would have been payable in that case. There is no fraud upon the corporation, nor had they sustained any injury by plaintiff's description of himself as a photographer and tutor. The court said if the financial status of the proponent is a material fact in the eyes of the insurers, they should ask the question in plain terms. Under the general law of insurance, an insurer can avoid a policy if he proves that there has been misrepresentation or concealment of material fact by the assured. What is material is that ZVHICH would influence the mind of a prudent insurer in deciding whether or not to take the risk. Risk. What was not asked from the proponent at the time he made the proposal and the personal statement obviously could not form the basis of the contract. There was no statement on the subject of income in the proposal or any other document leading to the issue of the policy. The burden under S. 45 was on the insurer to show that the suppression of the fact was a circumstance which it was material to disclose and its suppression was fraudulent, and that the policyholder learned at the time of making it that his statement about occupation was false, that it suppressed facts which it was material to disclose. Nothing short law of insurance 10.45 of the deliberate fraud has to be proved by the insurer if the policy is called in question after 3 years. The corporation had utterly failed to discharge the onus. Thus, the court held that the plaintiff was entitled to the decree for Rs. 25,000 with interest. Kami Bai V. LIC of India. Air 1981 Madhya Pradesh 69. Note, the case deals with the deliberate wrong statement of age of the assured. Facts: the husband of the plaintiff insured his life with the defendant, respondent with effect from the 18th of March 1970, which was to mature on the 1st of March 1976 for Rs. 25,000. The insured died on the 8th of August 1971 on account of congestive cardiac failure. The insured had declared his age 48 years in the proposal as well as in his personal statement and had submitted the horoscope in proof of his age, on the basis of which the respondent had admitted the said age. On the death of the insured, his widow, the appellant, made a claim for Rs. 25,000 as nominee of the insured. The respondent repudiated the claim of the insured. The respondent repudiated the claim of the plaintiff appellant on the ground that at time of insurance the insured was of non-insurable age of 60, but he had induced the respondent to insure him, giving a false statement about him. The insurer sought to prove the age on basis of I. partnership deed between him and other persons filed with the registrar of firms, E. application with income tax department filed for registration of firm, and E. entries in voters list. Decision. The court held that when the documents showed that the insured was more than 60 years of age at the time of taking the policy, the lower age as shown in the proposal and admitted by the insurer could not be taken to be correct age. The court said that S. 45 of the Insurance Act, 1938 enables the insurer to readjust the premium payable by the insured when the age stated is found to be incorrect on calling for the proof of age after issuance of the insurance policy on the basis of age that was mentioned in the proposal. The proviso does not take away the right of the insurer under the body of the section to avoid the policy on the ground of fraud. The insured on the date of the proposal very well knew that he was aged over an NHOVP 60 years. Nos VRN? This fact, he deliberately made a false statement about 10.46 General Principles of Insurance. His age, that he was only 48 years of age. By making this statement he led the respondent to insure his life and thus practiced a fraud. In this view of the matter, the court held that the policy cannot be enforced. Thus, the respondent was held to be right in avoiding the policy and refusing the payment of the claim. Rati Lal and Company v. National Security Insurance Company Limited. Air 1964 SC 1896. Note, the case deals with the importance of cover note. Facts. The plaintiff appellant proposed to effect insurance against fire and offered to pay the premium to insure goods to the extent of Rs. 100,000. The risks to be covered were as per the policy No. 26,625 dated the 5th of March 1952 for 12 months from November 1951. He was issued a cover note wherein it was stated that the protection was in force for 30 days or until the policy was prepared. He was issued an unstamped letter of cover dated November 5, 1951. The fire over which the claim is based occurred on the night of November 4, 1951 or during the early hours of the morning of the next day. The respondent admitted liability on policy No. 26,625, but with regard to the letter of cover it contended that the letter was not admissible in evidence for want of stamp. Stamp issue. Whether the letter of cover can be admitted in evidence? Decision of the Supreme Court. The court stated that the question depends on some of the provisions of the Stamp Act, 1899. S. 35 of that Act provides that no instrument chargeable with duty shall be admitted in evidence for any purpose unless such an instrument is duly stamped, provided that any such instrument not being an instrument chargeable with a duty not exceeding 10 naya paise only or a bill of exchange or promissory note, shall, subject to all just exceptions, be admitted in evidence on payment of the duty with which the same is charged together with a penalty of. Under N 47 of Schedule 1 of the Stamp Act, 1899, the minimum duty chargeable on policy of the fire insurance is 50 naya paise. This article contains at the end a general exemption which is in these words: letter of cover or engagement to issue a policy of insurance, provided that unless such letter or engagement bears the stamp prescribed by this Act for such policy, nothing shall be claimable under Law of Insurance 10.47. Nor shall it be available for any purpose, except to compel the delivery of the policy therein mentioned. The court stated that a letter of cover is contract granting insurance for a period between its date and until a policy is prepared and delivered if one is eventually issued or otherwise is up to a date mentioned in it, just as period of 30 days is mentioned in the present case. It gives protection for 30 days or the period up to the date of issuance of the policy. Tire Court held that a letter of cover is not exempted from duty in all cases. When it is not exempted, it is an instrument chargeable to duty. By the use of words, bears stamp, the legislature intended to convey that a letter of cover would be chargeable to duty in all cases except for compelling delivery of a policy. Therefore it was held that a letter of cover is an instrument chargeable to duty under the Act and so admissible in evidence in payment of requisite duty and penalty under S. 35 of the Stamp Act. Tire idea of exempting a letter of cover from payment of duty was to avoid the hardship of payment of duty twice over the same insurance, for the policy issued after the letter of cover had to insure the goods from the time that the letter of cover itself insured them and the policy had to be stamped. Secondly, in very few cases it would be necessary to enforce the letter of cover as an insurance, for it is unlikely that in many cases the fire would have occurred during the period covered by it. Therefore, the appeal was allowed.